In this lecture, we shall discuss the drafting of an application for judgment in default of appearance. The drafting of an application for judgment in default of appearance. Now, if you take a look at the rules, specifically Order 9 of the CI 47, you will notice that under Order 9 Rule 5, there is a timeline that has been prescribed for the defendant to enter appearance. Order 9 Rule 5 provides that after the writ has been served on the defendant, then the defendant has 8 days within which the defendant must enter appearance. 8 days after the writ of summons has been served. 8 days after the service to enter appearance. Now, if the defendant fails to enter appearance, then the plaintiff is entitled to apply for judgment in default of appearance. And we shall look at how do we draft this application for judgment in default of appearance. Judgment in default of appearance has been provided for under Order 10 of the CI 47. Now, the first thing you need to notice is that if you are applying for the judgment in default of appearance, the relief that you seek, what you are praying the court to grant you judgment for, it will be dependent on the nature of the claims you are seeking before the court. And let me explain this. If you look at Order 10 Rule 1, if your claim before the court in your writ of summons that you have, let's say Rule 1, is for a liquidated claim, let's say recovery of the sum of 50,000 cedis, which you advance to the defendant that he received on this day. Liquidated claim. That one under Order 10 Rule 1, we are told that you apply for final judgment. So if your claim is a liquidated claim, then you can apply for summary judgment, final judgment in default of appearance. Final judgment. If it's a liquidated claim, you go for final judgment. But if it's an unliquidated claim, for example, you are asking for damages, we can't tell what the damages, how much you are asking for. You're asking for general damages. So the court must take evidence to assess it. That's one. And under 10 Rule 2, you apply for interlocutory judgments. And under 10 Rule 2. And then, if you are claiming for detinue, look at Order 10 Rule 3, which will show you what the reliefs you must seek for are. And if you are claiming for possession of immovable property, look at Order 10 Rule 4, which will show you what you must seek for. Remember, you are going for judgment in default of appearance because you are saying that after you serve the defendant with the writ, the defendant has not entered appearance. But how do you demonstrate to the court that the defendant hasn't entered appearance? You conduct a search in the court, a search like this. Please conduct a search in the registry of the courts to ascertain the following: whether or not the defendant has been served with the plaintiff's writ of summons. Do answer yes. Whether or not the defendant has been entered appearance to the writ of summons, and the answer will be no. So this is a search that you attach as your exhibit to your application to show the judge that you have indeed served him and the defendant has not responded. So take note of these points before we begin our application, because they will inform the content of our affidavit. So we shall now begin with the drafting of the application. Now, if you've seen a writ of summons before, it says that if you fail to enter appearance, then the court will proceed without further recourse to you. It means that if I serve you with the writ of summons and you fail to enter appearance, the writ itself has information over there that if you don't enter appearance, then the court shall proceed without further recourse to you. So because of the people have always argued that for judgment in default of appearance, we can go on an ex parte application. And indeed, people indeed apply and go on an ex parte application, and by practice it is allowed. Subject to any rules changing later on. For now, application for judgment in default of appearance, we are allowed to go ex parte, even though people share a contrary view. So, ex parte application, straightforward. We have our title in the Superior Court of Judicature, in the High Court of Justice, and then the year over there. We have our suit number CM419/2019. Then parties, we have Milstego and his address, house number 11 Tema. Plaintiff applicants, and you have Jack Mensah, house number 5, community 1 Tema. But over here, we don't make Jack Mensah a defendant respondent. Why? Because it's an ex parte application. And if it's an ex parte application, then he will not have a respondent, because we are moving on an ex parte application without notice to the defendants. So our heading, motion ex parte for judgment in default of appearance, pursuant to Order 10 of the CI 47. Now, how do we go about the motion paper? Very simple, standard motion paper. You can take a look at it. Standard motion paper. Motion ex parte by Babatando Esquire, counsel for and on behalf of the plaintiff applicant, praying for, let me make it, judgment in default of appearance against the defendants herein upon the grounds set forth in the accompanying affidavits. And for any further orders as this honorable courts may deem fit. Court will be moved on so and so day at 9 o'clock in the forenoon or so soon thereafter, as counsel for the plaintiff applicant may be heard. Dated at Babatano and Associates, this 29th day of October 2021. Remember, the lawyer must sign. You address it to the registrar. Add the lawyer's license number over there. But please don't go and write and for copy of service on this person, because it's an ex parte application. So you don't go and do direct service on the defendant. Ex parte, you are going alone. So you don't go and write and for copy of service on the defendant. No. Don't go and write this one. So this is the motion paper. Then we can move on to the affidavit. Very simple affidavits. Very simple affidavits. Remember the things that you must prove. If it's liquidated, you go for final judgment. Unliquidated, interlocutory judgments. And remember, you must demonstrate that you have indeed served the defendant, but you have not entered appearance. And I remember we mentioned that you do that proof by attaching a search. So let's look at affidavits now. Same title. Remember, don't make it defendant respondent, because it's only defendant. There's no respondent, because it's an ex parte application. So, affidavit of James Hughes in support. This affidavit is being deposed to by the law clerk of the plaintiff applicant. But as for affidavit, the plaintiff himself can depose to it, or anybody that has personal knowledge of the information and can prove can also depose to it. So do not see this procedure as standard. It is standard to the extent that it's the clerk that is deposing to it, but nothing stops you from making your deponent Milstego, who's the plaintiff applicant himself. I decided to use the law clerk to depose to this affidavit. So I, James Hughes, of the address will follow. Plot number 419B, 9th Ostro Street, South Lai Estates, Accra, in the Greater Accra region of the Republic of Ghana, do hereby make oath and say as follows. So you must state your position, that I'm the deponent herein and the law clerk of the Tando and Associates, which is the law firm mandated by the plaintiff applicant to handle this case. That I have full authority of the plaintiff applicant to depose to this affidavit. Let me add of facts, which are within my personal knowledge as a result of the instructions given to my law firm to handle this case. Okay, let me make it, which have come to my personal knowledge as a result of the instructions given to the law firm, my law firm, to handle this case. Yes, because remember under 20, you must depose to facts that you know of, and if it came into your knowledge, you must show how the facts came into your knowledge. We can even add that to the extent also that any of the depositions contained in this affidavit is anchored on law, then same is being made upon advice I have received from my lawyers, and I verily believe same to be true. That if, apart from the matters of fact that you know of, if you are going to say anything about law, that one you don't know the law. If the lawyers that advise you and then you are aware of that, you believe same to be true. So now let's go on. Paragraph 4, that at the hearing of this application, counsel shall seek leave of this honorable court to refer to all processes filed in this suit as if same have been annexed to this affidavit and sworn to. Then paragraph 5. That sometime on or around April 2021, the plaintiff applicant commenced the present action against the defendants. So we are not supposed to have defendant respondents. Against the defendants for the following reliefs endorsed on the writ of summons. A. Recovery of the amount of 50,000 cedis representing the value of goods defendant bought and has refused to pay for, despite repeated demands. Interest on the sum of 50,000 cedis at the prevailing commercial lending rates calculated from April 1st, 2019 to date of final payment. Damages for breach of contract. Paragraph 7. That the writ of summons and statement of claim were served on the defendant. And paragraph 8. That even though the time for filing appearance has long elapsed, a search conducted in the registry of this court reveals that notwithstanding the fact that the defendant has been served with the writ of summons, the defendant has neither entered appearance nor filed his defense. So attached herewith is a copy of a search confirming that the defendant has indeed been served with the writ of summons and has also not filed an appearance marked as Exhibit A. So over here, now for the defense, you can skip it. But in this case, I'm just leaving it over there. Because all you need to show is that the defendant hasn't filed his appearance at all. So you can even leave this, that the defendant has not entered appearance. Has not entered appearance to the writ of summons. Right. Attached here is a copy of the search confirming that the defendant has indeed been served with the writ of summons and has also not entered appearance as marked as Exhibit A. So you see, the single search that we looked at, this search, it has first question, whether or not he has been served with the writ of summons. The answer is there. And whether or not he has entered appearance. So this search is serving two purposes. It is showing that the defendant has been served, but has also not entered appearance. That's why we are adding all to the same paragraph. Then paragraph 8, that I'm advised by counsel, and I verily believe him to be true, that by the rules of this honorable court, the plaintiff applicant is entitled to be granted judgment in default of appearance against the defendant herein for the reliefs endorsed on the writ of summons. Remember over here, I didn't mention final or interlocutor, I just said judgment. But if you look at my paragraph 9 now, I will now specify. Wherefore, I pray that this honorable court enters final judgment in default of appearance. So I'm asking for final in respect of reliefs A and B. If you remember, relief A is what deals with the recovery of this amount. So these ones are liquidated, so I can take final judgments. So these ones are liquidated, that is the principal sum and then the interests. So I can take final judgment for those ones. And then if it comes to interlocutory judgments for relief C damages, so that one I'll take interlocutory judgments. So you see, so I'm asking for final judgment for relief A and B because they are liquidated claims, and I'm asking for interlocutory judgments for relief C because that is for unliquidated. Wherefore, I pray. That's all. Sworn at Accra this day in 2021. Deponent signs, then we have commissioner for oaths. Now, after this one, the next thing that we usually add would be a search, because you might attach a search to the copy of the application to show that you have indeed served them, but you've not entered appearance. And then under Order 20 Rule 14, then you can add your certificate of exhibits to show that the commissioner has identified the exhibit to your affidavit before he gave you. So by way of recap, remember, if it's for a liquidated claim, you get some final judgments. Unliquidated, interlocutory, letting you look at what you get, possession, see what you get. Remember, you must show that you have served the defendant with the writ, but he has not entered appearance, and you show that by conducting a search. This is how the motion paper looks like, and this is how the first page of the affidavit looks like, and then this is how the second page of the affidavit looks like. I've given different colors just to draw your attention to why we are asking for final judgments for relief A and B and interlocutory for relief C. And then you have our search over here, and then we have our certificate of exhibits. This shall be the end of our lecture on drafting an application for judgment in default of appearance. All you must show are your reliefs. Show what judgments you can get for each relief and prove that indeed the defendant has been served and has not entered appearance. Thank you.